Hello, everyone. Good afternoon, and welcome to this week's Business in 2021 webinar presentation. My name is Kathy Purdy, and I'm a marketing manager here at Bond. I'd just like to go over 2 quick housekeeping items before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and we will do our best to answer those as time allows. Once the webinar has ended, if you would take a moment to complete the survey, we would appreciate it. Your comments and suggestions are important to our panelists and provide us with topics for future presentations. It is now my pleasure to introduce today's moderator, Adam Mastrolio.
Kathy, thank you so much, and welcome to everyone who is joining us this afternoon for our weekly installment of Bond's Back in Business presentation. There is a lot going on, quite a few developments that we have to talk to you about today. We have an awesome panel. And hopefully we provide you with a lot of good information that is helpful to you as you manage your business. So without further ado, our first presentation is from Stephanie Fedorka. You've seen Stephanie on this webinar many times before, talking about a variety of topics, but recently Stephanie has been focused on the New York HERO Act. And I will dare to say that Stephanie has read the HERO Act more than the drafters did. So Stephanie is going to talk to us today about the second part of the HERO Act, primarily, but also to give us a recap and update. So Stephanie, welcome, and thank you again for being here. Take it away.
Thanks, Adam. Always a pleasure. Happy to be back on and talk a little bit more about the HERO Act. We're going to focus our discussion a little bit today about part 2, but I wanted to provide a quick update on part 1. So if you recall, the New York HERO Act was passed back in May, and it really is 2 parts. It breaks down into 2 parts. The first part that we have spent the past several weeks talking to you about and providing updates on, which is Section 218B of the New York Labor Law. That has to deal with the occupational airborne infectious disease exposure prevention and those HERO Act plans that went into effect back in July. And we are currently still under a designation by the New York State Commissioner of Health. That designation was originally issued on September 6th, designating COVID as a highly infectious communicable disease that triggered activation of your plans. That designation was subsequently extended through October 31st. The second part is the New York Labor Law, Section 27D, that has to do with workplace safety committees. That's going to be today's focus. We're going to recap a little bit about what those provisions are. That goes into effect November 1st, and provide you an update on where we're at. Next slide, please. So again, a really quick recap on this first part of 218B regarding your New York HERO Act plans. I mentioned on the last slide that the designation is still in effect and it's extended through October 31st, subject to review at that time. Katie's going to give you a little bit more information on that piece and what we may anticipate from the Commissioner of Health on whether or not this will be extended, but you have to have your New York HERO Act plans implemented and in place while the designation is in effect. So I guess we will have to wait and see if it's further extended, but Katie will have more information on that in a little bit. Next slide, please. So again, the focus today is on this second part regarding the workplace safety committees. This is in a different part of the labor law. It's Section 27D. This covers private employers with at least 10 employees. So this is different than the definition under the other part of the HERO Act. So this only applies to private employers with at least 10 employees. The obligation here, the main core of it, is that employers are required to permit employees to establish and administer a joint labor management workplace safety committee. So ultimately, it allows employees to establish these types of joint labor management workplace safety committees that comply with certain requirements that we'll talk about on the next slide. Becomes effective November 1st. The Department of Labor has promised to issue guidance before November 1st. So we are anxiously awaiting any updates that they may provide this week. Trust me, I have been refreshing my browser, so you don't have to, and we will certainly update you with any additional guidance they provide. But let's recap what's in the law itself. Next slide, please. So these workplace safety committees, if employees request to create these committees, they need to be at least 2/3 non-supervisory employees. They must be co-chaired by a representative of both the employer and non-supervisory employees. Selection employee members, so the non-supervisory employees, have to be selected by and from among other non-supervisory employees. If you're in a situation where you have a collective bargaining agreement, the collective bargaining or a unionized setting, the collective bargaining representative is going to be responsible for selection. The statute provides that geographically distinct work sites may have their own committee if necessary, but it also provides that if an employer already has a workplace safety committee that otherwise complies with the requirements under the law, they're exempted from creating a new or another additional workplace safety committee under this section. Next slide, please. There's a prohibition on employer interference. So employers must not interfere with either the selection of employees who serve on such a committee or who serve as a workplace safety designee, as well as employees' performance of authorized duties, which we'll talk about on the next slide. Next slide. Thank you. With respect to what these workplace safety committees are authorized to do under the law, the statute is clear that they have these several enumerated duties that they can engage in. They can raise health and safety concerns, hazards, and complaints and violations. If they do so, an employer has an obligation to respond. They have the authorization to review any policy put in place in the workplace required by any provision of the occupational safety and health aspects of the law and provide feedback. One piece of guidance that we have a little bit that we have to work with from Section 1 of the New York HERO Act, their current guidance provides a little insight on if you have one of these workplace safety committees and you make any revisions after November 1st to your New York HERO Act plan, these workplace safety committees may be authorized to review and provide feedback on any subsequent modifications. But I'm sure we will see more guidance from that, from the Department of Labor this week on those additional authorizations or duties or responsibilities. These workplace safety committees can review adoption of any policy in the workplace in response to any health or safety law, ordinance, rule, or regulation, as similar to what I just mentioned. They can participate in any site visit by governmental health and safety agencies unless otherwise prohibited by law. They can review any report filed by the employer related to health and safety of the workplace. And they can regularly schedule a meeting during work hours at least once per quarter. But those meetings cannot last any longer than 2 hours. Next slide, please. In addition, the statute provides some information on training. Employers must permit the safety committee designees to attend training on the function of worker safety committees, rights established under this part of the HERO Act, this New York Labor Law, Section 27D, and training related to introduction to occupational safety and health. The statute does provide that that's limited to a max of 4 hours, but it's a little unclear whether or not that's a one-time training per employee or if it's something else, if that's going to be, every year or something along those lines. And it's got to be without loss of pay. So in other words, it's got to be this time that they spent training or engaged in this training must be paid. Next slide, please. In addition, there are protections for employees. Retaliation is prohibited for employees who participate in activities or establishment of a workplace safety committee under this law. And it also incorporates remedies for retaliation existing under Article 7 of the New York Labor Law, which entitles or authorizes the New York State Department of Labor to investigate and issue civil penalties if there's a violation. They can also file a private right of action under limited circumstances as well. So employees are protected from retaliation for engaging in their exercising of their rights under this part of the New York HERO Act. Next slide, please. With respect to collective bargaining agreements, obligations under this section is also waivable. However, for it to be valid, there must be an explicit reference to this section of the New York Labor Law. And that's only in circumstances where you have a collective bargaining or a unionized work setting. And nothing in this section diminishes the rights, privileges, or remedies of an employee under an existing collective bargaining agreement as well. Next slide. Oh, and that's where we are at. So stay tuned. I'm sure there will be more to come, and we will update you whenever we get that new guidance from the Department of Labor.
Stephanie, thank you so much. Before we move on to Teresa, I just want to address a couple of the questions that we're getting in the Q&A section. And these are the same questions I've been getting from clients. A lot of clients are wondering, do I have to set up one of these committees? Does the statute require me to do that? Now, my reading of the statute is that there is no affirmative obligation to set up these committees, but how are you reading the statute?
I read it the same way. The statutory language is very interesting because it says that employers are required to permit or shall permit, which is permissible. It doesn't say they shall create. So I think based on the plain language in the statute, my position has been that employers don't have an affirmative obligation, like you said, to create these, but rather if employees say they want to create them, then you would have to allow it.
And then the second question that I've been getting a lot, and I saw it in the Q&A as well, is whether or not an existing workplace safety committee could possibly pass as satisfying the requirements of the statute. And my understanding is that in theory, yes, so long as they meet that existing workplace safety committee meets the requirements set out in the statute. Is that your understanding as well?
Yes, I think that's also addressed in the statute. So if you already have a workplace safety committee and it conforms to those requirements, I think you would be exempt from having to create a new additional workplace safety committee.
Perfect. Well, thank you, Stephanie. That was very helpful as always. We will obviously keep an eye out for any guidance from the Department of Labor, and we'll put out both a blog post and potentially have a pop-up webinar for you all on those issues or on the FAQs. Because as we've learned from the other guidance, when the FAQs are issued, there's often a lot of new information that the state may have not have included in the statute and decided to put in the FAQ. So we will keep an eye on that for you and communicate with you about it. All right, next up is something that is hot off the press and very important. The EEOC, for whatever reason, finally decided to weigh in on vaccine mandates. As most of you are probably aware, there is an ongoing debate about religious accommodations as they relate to vaccine mandates. So here to talk to us about the EEOC's guidance is Teresa Rusnick. You've heard Teresa speak many times on this webinar, and I know she's on top of this today. So Teresa, please take it away.
All right, thank you. If I could have the first slide, please. So, as Adam said, this is hot off the press. Yesterday, the EEOC released guidance specifically addressing whether employers must grant religious accommodations when a vaccine mandate is imposed, and they said that you do. Overall, the guidance states that a failure to provide for religious accommodations with regards to vaccine mandates is a violation of federal law, specifically the Federal Employment Law Title VII. So this, as Adam said, this is pretty significant. We didn't necessarily know the EEOC was going to weigh in on this, but given the different court decisions and different mandates that we've seen at the federal and state levels, I guess they decided that they would or needed to. And so they have pretty much stated in irrevocable terms that the failure to provide for or at least consider religious accommodations is going to be a violation of Title VII in their view. As we know, as an administrative agency, their view is usually entitled to some deference by courts. I'm not saying the courts have to follow the EEOC's interpretation of Title VII violations, but it's likely that they will look to them for guidance and that they very well may. Also, we know that the EEOC has the ability to investigate employers on its own initiative and also receive complaints from employees. So to the extent that an employee makes a religious accommodation claim to the EEOC as a violation of Title VII with regards to one of these mandates, that's definitely something employers are going to not want to have happen to them and are going to want to know how to defend themselves against. So that's what we're going to be talking about. If I could have the next slide. So employees in general must tell their employers when they have a religious objection to receiving the vaccine. Much like with a disability accommodation, employers aren't expected to divinely intuit when or not someone's going to have a religious objection. The employee is obligated to tell the employer when they have one. Specific language is not required on behalf of the employee. They don't have to say, I am claiming my right to a religious accommodation under Title VII of the Civil Rights Act of 1964. They don't have to be that specific, but they have to give enough information to inform the employer that there's a conflict between their sincerely held religious belief and the vaccine mandate that's been imposed. The same requirement would apply if the employee has an objection to a particular vaccine type or a particular dosage of the vaccine that's based on religion. Perhaps they don't have an objection to vaccines or this vaccine, just a particular type of vaccine or dosage of the vaccine. You should, as a matter of best practice, inform your employees about who to contact and how to request a religious accommodation. If you're issuing a mandatory vaccination policy and or you are trying to issue a policy to comply with a federal or state mandate, please include information on religious accommodations, including who people are supposed to contact and how to request a religious accommodation, preferably far ahead of the date that the vaccine mandate is going to be imposed or effective. Next slide, please. Generally, under Title VII, an employer should assume that a request for religious accommodation is based on sincerely held religious beliefs. The EEOC and federal courts in general have been pretty queasy about getting into the nitty-gritty of people's religious beliefs, but I actually think in this guidance, they go farther than they've gone in the past because they know that this is such a hotbed issue, and they go into more detail than I've ever seen them go into about what an employer is allowed to question and what an employer is allowed to ask. Even their language that an employer who has an objective basis for questioning whether the religious nature or the sincerity of the belief exists, the employer is justified in making a factual inquiry, limited, and seeking additional supporting information. So, typically where we would advise you don't question it, you have to assume it's sincerely held. Here we're seeing that you can, if you think it may not be sincere, ask for a little more information. And an employee who fails to cooperate with your reasonable request for verification of the sincerity or religious nature of their belief risks losing any claim that the employer improperly denied their accommodation. So not only if you have an objective basis, can you ask about it? If someone refuses to cooperate with you, they're going to have trouble saying that they were incorrect when you failed to accommodate them. So that again gives employers a little more leeway than we've seen in the past with this topic. Next slide, please. To that point, though, the EEOC wants to remind everybody that the definition of religion under Title VII protects non-traditional religious beliefs that may be unfamiliar to employers. Employees may be asked to explain the religious nature of their belief and should not assume that the employer already knows or understands it. So that means you don't have to take the employee quite at their word. If they're giving you a religious belief or a purported religion that you've never heard of, you can ask them, how to explain their belief, and you can ask for an explanation of how the employee's religious belief conflicts with the employer's COVID-19 vaccination requirements. So you can be that specific. And again, if you have a good faith belief for believing that it's not a legitimate or sincerely held religious belief, the employee has to cooperate with your request for more information or additional explanation. Next slide, please. The EEOC notes, and this has been their longstanding position, that the employee's sincerity in holding a belief is largely a matter of individual credibility, but what they haven't done before is give us a list of factors that may undermine credibility, particularly with regards to the vaccine mandate. So, and this is not a very specific list. It's a little more vague than perhaps I would have liked, but it is at least a list. It's a place to start. So the EEOC lists factors that may undermine credibility in this area as actions of the employee that are inconsistent with their professed beliefs, whether the accommodation sought is desirable for non-religious reasons. So that can be a factor that undermines credibility. Timing of the request renders it suspect, and the EEOC gives the example of the request following a non-religious request for the same. So if somebody says to you, I need an accommodation because I don't want to get the vaccine, because I don't like it. They don't mention religion. They don't say it's because of a sincerely held belief. And then a couple days later, they say, hey, I can't get the vaccine because my religion says I can. I have a sincerely held religious belief. That timing is what the EEOC is getting at to say that the request may be suspect because of that. And then they give the employer a little bit of leeway and say other reasons to believe the accommodation is not sought for religious reasons. For example, one of the ones that I've heard is an employee is asked, are you objecting for religious reasons? And they say, no, has nothing to do with religion, has to do with my rights as an American citizen and the Constitution. It has nothing to do with my religion. And then a week later they say, oh no, it's because of my religion. It's because of my sincerely held religious beliefs. That could be a reason to believe that the accommodation is not necessarily being sought for religious reasons because the employee has told you initially that it wasn't being sought for religious reasons. Next slide, please. The guidance also says specifically that Title VII does not protect social, political, or economic views or personal preferences. So objections to the COVID-19 vaccination that are based on social, political, or personal preferences or on non-religious concerns about the possible effects of the vaccine do not qualify as religious beliefs under Title VII. You may very well want to put this language in your policies. When you're putting in the language about you can request an accommodation for sincerely held religious beliefs, you may want to put in this language, objections to the COVID-19 vaccination, etc. This is taken directly from the EEOC's guidance. So again, this is the EEOC saying you do have to accommodate people based on their sincerely held religious beliefs, employers, but you don't have to on the basis of their social, political, economic views, or just personal preferences. Next slide, please. It says the EEOC guidance says an employer should thoroughly consider all possible reasonable accommodations, including telework and reassignment, perhaps to a different job, perhaps to a different area of the company, or a different shift or something like that. So, like with a disability accommodation or medical accommodation, you need to consider all possible reasonable accommodations. And the EEOC lists those two as examples. Much like with the medical accommodations, if an employer demonstrates that it's unable to reasonably accommodate an employee's religious belief without an undue hardship on its operations, then the Title VII does not require the employer to provide the accommodation. The undue hardship analysis, which we're going to get to on the next slide or the slide after, is different in the religious context than it is in the medical context. In a way that it gives more leeway to employers to define what an undue hardship is. However, in any circumstance, medical or religious, the determination of whether a particular proposed accommodation imposes an undue hardship is dependent on the specific factual context. The guidance goes out of its way to say that just because it's an undue hardship for one employee to have an accommodation doesn't mean it's going to be an undue hardship for the next employee to have a religious accommodation. So it really does need to be based on the specific factual context. Next slide, please. So this is where I'm talking about the undue hardship analysis under religious accommodation standards, which the EEOC has said applies to the vaccine mandate. The Supreme Court has held that requiring an employer to bear more than a de minimis or minimal cost to accommodate an employee's religious belief is an undue hardship. Costs to be included and considered include not only direct monetary costs, but also the burden of the conduct on the employer's business, including in this instance, the risk of the spread of COVID-19 to other employees or to the public. For example, per the EEOC, the religious accommodation would impair workplace safety, diminish efficiency in other jobs, or cause coworkers to carry the accommodated employee's share of potentially hazardous or burdensome work. So these are the things the EEOC is saying could contribute to an undue hardship analysis in the religious belief context as it pertains to the vaccine mandate. Next slide, please. If there is more than one reasonable accommodation that will resolve the conflict between the vaccination requirement and the sincerely held religious belief, the employer may choose which accommodation to offer. Just because an employer requests a specific accommodation does not mean you have to give them that accommodation. If there's another accommodation that wouldn't cause an undue hardship to you and that would also resolve the conflict between your vaccination requirement or the vaccination requirement the government's requiring you to impose, and the individual employee's sincerely held religious belief. And then finally, the obligation to provide religious accommodations absent undue hardship is a continuing obligation that takes into account changing circumstances. So, while it may be a permissible religious accommodation that you can provide 1 month and it doesn't cause you an undue hardship, if something changes with the employee's accommodation or with your business, it may at a later point become an undue hardship. Of course, that can work the other way as well. What may have been an undue hardship at one point may at a later point be something that you can accommodate without an undue hardship. So the EEOC leaves us with the idea that this is a fluid, dynamic situation, and employers should be flexible in having these accommodations in the workplace. So bottom line, you do have to consider religious accommodations if you don't want to run afoul of Title VII when it comes to your employees and vaccine mandates, but that doesn't mean that you have to accommodate people based on their personal beliefs or preferences or, social, economic, or other views that are other than religious. Okay, so I know that was a lot in a couple of minutes. I encourage you to look at the EEOC's full guidance if you haven't already had a chance to do so. I definitely think it's worth reading in its entirety.
Teresa, thank you so much. Just for everyone's benefit, I put a link in the chat to the
Oh, thank you, Adam.
Yep, no problem. So it's there. Now, we're getting a lot of questions, as you can imagine, about what to do in very specific situations. And what I'll say to that is, if you have a question about a specific situation, reach out to us offline so that we can guide you. Religious accommodations have always been a tricky subject.
Very true.
They've never been an easy thing for employers to handle. Vaccine mandates just highlight the difficulty that employers face when considering these religious accommodation requests. So if you have a specific situation that you're concerned about, please reach out. Now, one thing I will point out, the guidance does not address specifically what to do if you're, let's say, a hospital and you have a vaccine mandate that is imposed by regulation from the state of New York, and that regulation does not permit religious accommodations. So the EEOC guidance, I just want to make sure it's clear, doesn't address that, doesn't talk about that situation. It talks about the fact that generally religious accommodations have to be provided, and here are some of the things that you should consider when you are when you receive a request for religious accommodation to your vaccine mandate. So a couple of additional points. Teresa, thank you very much. That was a lot of information. Like you said, there's a lot that the EEOC put out. So we would encourage you to review it, and if you have questions, to please contact us. All right, next up, Larry Fennell from our New Jersey office, recently opened New Jersey office, is going to talk to us about a recent law that was passed regarding retirement accounts in New York State. So Larry, welcome, and please take it away.
Hey, thank you very much, Adam. Good afternoon, everyone. On October 21st, the governor signed off on new legislation which required private employers, smaller employers who don't sponsor a retirement plan for their employees to automatically enroll their employees into a new program. The law amends a prior law which set up a similar program, making it optional for employers to opt into this. The new law now makes it mandatory for certain employers to provide this benefit to their employees. The program is essentially an automatic IRA program, falling in line with traditional best practices for retirement savings vehicles, and looks to maximize participation and encourage savings towards retirement for employees and with smaller employers who don't have access to a traditional 401k plan or other tax qualified retirement plan for their employees. New York State will appoint a 9-member board to oversee the plan, and this act takes effect immediately. Now, I think the devil's in the details there a little bit, and we'll get into it a little bit more as we go forward, but more to come as far as the board is concerned with respect to this. And once the final rules are put in place and the board has provided some additional guidance, or at least we anticipate will provide additional guidance, employers will have a 9-month period to get up to speed and get their employees into this program. So moving on to the next slide, there's some highlights here regarding the program. I'm not going to touch on all of them here, but you're looking at fiduciary duties that are set by state statute that are very similar to those found in ERISA, where the purpose is, the exclusive purpose of this plan is to provide retirement benefits to enrollees and their beneficiaries. You're looking to defray expenses, and only ensure reasonable monies are spent on the administration of the plan, investing with care, skill, and prudence and diligence, and using contributions to provide retirement benefits to the enrollees and their beneficiaries. Similar to a 401k plan and other defined contribution retirement plans, you're going to find in this program a default investment option for people who don't elect to affirmatively elect an investment option, along with an array of different types of investments that will be made available. Participants will have the opportunity to select their investment, or will be put in the default investment if they don't make an election. The state's going to be contracting with various service providers in the same manner an employer probably would. They'll be doing periodic reviews of performance by different investment options and presumably vendors, and put together an enrollment process, offer education to participants, and send out informational materials. In time, there's a provision that says they may look to deal with other issues such as like a hardship withdrawal or participant loans, but time will tell where the state ends up going with that particular provision. Taking a look at the next slide, just again, some highlights here. Employees are going to be allowed to make contributions up to the code, the Internal Revenue Code federal limit for IRAs, which currently stands at $6,000. There's also an additional $1,000 in catch-up contributions. There's no reference made there, but presumably employees will be allowed to make that contribution if they follow that Internal Revenue Code limit. The default rate of investments contribution will be 3%. Employees can change that at any time. Employees can also opt out of the plan and not make any contributions. They won't be mandated to make contributions if they choose not to do so. However, unlike a employer plan where you usually can get back into the plan at any time, subject to the terms of that plan, here you're going to have an annual open enrollment period where employees will have a chance to get back in the plan. So you can opt out, but you'll have to wait to opt back in. As far as employers go, this is going to apply to, first and foremost, employers who don't have a retirement plan. So if you sponsor a retirement plan now, this is not going to apply to you. Then, we drill down into the details a little bit, and we're dealing with employers who have had at least 10 employees in New York State at all times during the prior calendar year. So right now you'd be looking at presumably 2020, and you had to have 10 employees the whole time. So if you had 9 employees at any time, I think you would not be subject to this rule. You have to have been in business for at least 2 years. It appears that applies to not just New York State, but anywhere. And you cannot have offered a qualified retirement plan within any time during the prior 2 years. And there's a point being made that employers can't terminate their plan in order to participate in the New York State program. And that kind of makes sense if you think about the fact that if you offered a plan within the past 2 years, if you did terminate it, you can't opt into this program. That seems to follow that logic there. Looking at the next slide, we're looking at required disclosures. And in a nutshell, this appears to be very similar to the types of materials employers would provide their employees who are looking to participate in the plan, very similar to the information found in summary plan descriptions and other administrative forms, looking at the benefits and risks of participating and making contributions, how to enroll, how to make contributions, how to opt out of the program. This information is going to be required to be provided by employers to employees. However, we anticipate that the board or the state of New York's board or otherwise will be providing a template of information. I think more to come on that at this particular point in time. In addition to those disclosures, employers will be required to provide an opt-out form. The opt-out form is also going to provide an opportunity to select a different contribution rate. We'll see what it looks like ultimately, but there may be more information again, waiting and looking for guidance from the New York board on that. Skipping ahead to the next slide here, a slight comparison being made. New York City, as you may recall, put out, and I spoke on this a few weeks ago, a Retirement for All Act. And one of the key provisions of the Retirement for All Act was that if New York State put out a similar program covering the same employees, that the New York City bill would be vacated. Now, I hit on some of the key differences here that I came across. There may be some others, but these are the ones that stuck out to me. And I think the question that I have at least is, well, some of these things, for example, in New York City applied to at least 5 employers with 5 employees in New York. In New York City, New York State law only deals with those who had 10 employees within New York State. New York State has an 18-year-old minimum age. New York City has 20 hours, age 21 with 20 hours a week. There's no hour restriction on New York State. New York City, 5%, New York State, 3% automatic enrollment, no penalties at the state level, penalties for noncompliance at the city level. So it seems like this law is going to knock out the New York City law. However, I wouldn't bank on it until we necessarily, hear from the city and let them issue guidance saying that's not going to happen. But in a nutshell, neither program is up and running yet to our knowledge. We expect the city's going to discontinue their program. We'll, again, wait and see. But in any event, no matter where you are in New York State, if you're a small employer with 10 employees and you fall within that criteria and you're not offering a retirement program to your employees, you will have to affirmatively opt into this program or be required to opt into the program and have to work with the information provided by the New York State Retirement Board as far as administering this program. I expect more guidance here. The New York State law I felt was a little bit bare bones compared to the New York City law, but again, you're looking at a basic program that's going to follow a lot of the same tenets that you see in a 401k plan. I'm happy to answer any questions you may have. Feel free to reach out and we can work through this together. But thank you very much for your time today and have a great day.
Larry, thanks so much. Thanks for joining us. Larry is the expert in that stuff. So if you have any questions, reach out to him. Okay, last but not least is Katie for her weekly update from Albany. Katie, I'm sure, has some very interesting information for us. Katie, good to see you again.
As always, good to see you. And here we go. All right, so I am bringing us great news today, showing what's happening with the new reported cases in New York. You see, we're going down the graph. We love to see that. Absolutely love to see that. In the past 14 days, the rate of change has been a 24% decrease in cases in New York. So since the beginning of the month, we've seen it's around that same percentage of a rate of change. It's actually closer to 22%, but still great news. Happy to see that. And that will be an important point that I will be bringing up later, the rate of change. So So hang on to that number for just a little bit. I'll bring it back up at the end of this presentation. Looking at our vaccination progress in New York, we've seen our fully vaccinated numbers tick up 1 percentage point. I unfortunately don't have any news at this point for you regarding vaccines for kids 5 to 11. That news should be coming today. So keep your eyes out for that. The FDA is looking at Pfizer's data regarding vaccines for children 5 to 11 years old. So keep your eyes out for that. Next week, I'm sure I will have a lot more to report on that. If the FDA can get through it this week, that means the CDC can take a look at it and we can go from there. And so it goes. But there's plenty of other news to talk about. And while Teresa did a great job covering what's happening with the EEOC, it's been interesting to see the effect of mandatory vaccinations. If you look at this chart, you can see that New York State is the largest state with the highest ranking. So what does that mean? It's one of the, New York is the 4th largest state in the US. It is ranked, I'm counting really quickly, 6th on this list. So New York has the highest rate of fully vaccinated people out of any large state in the country. California is the next closest, and their rate of fully vaccinated people is at 60%. So what does this mean? Anecdotally, we've seen New York's fully vaccinated rate jump since the mandatory vaccine mandates came about, since there has been an effect from it, and it has boosted the vaccination efforts in New York. So, when you look at this cluster of states as well, it's consistent with what we've seen throughout the pandemic. It's the Northeast, and then New Mexico gets thrown in there as well. So that is good news and heartening news to take a look at. So turning to booster shot news, this is a big update, and this is, consistent with what we discussed last week. The CDC and the FDA have approved booster shots of Moderna and Johnson & Johnson. What does that mean? You can go out today and go get a booster shot if you are eligible for it. If any person who's eligible can go receive one. It doesn't matter which shot you get, and I will talk about that on 2 slides from now. So how can you get the booster? When are you eligible? If your first shot that you received, your first series was Johnson & Johnson, you are eligible to receive any booster shot with 2 months or more following your initial vaccination. So if I was vaccinated in May with the Johnson & Johnson, I would definitely be eligible by now. But if I was vaccinated on August, 15th, I would be eligible by this point to go receive a booster shot of Johnson & Johnson. Moderna and Pfizer, there are more rules involved, and we went over those rules last week. They are the same, but just for quickly, I'll just run through them. 65 plus, if you're 65 and over, you can go receive a booster shot. If you're 18 and over, living in a long-term care facility, you can go receive a booster shot. 18 and over with underlying medical conditions, you can go receive a booster shot. And if you're 18 and over, working or living in a high-risk setting, you can go receive a booster shot. Remember, last week we went into depth about what it means to be working within a high-risk setting. So if you have questions about that, go ahead, go to Bond's website. You can see all those materials there. And there is trick or treat or mix and match, COVID boosters this year. So what does that mean? It means that if you received any of the shots, you can receive any of them. So say I received the Moderna one, I can go and receive a Johnson & Johnson booster if that's what's available in the area. Generally, the reason for this is because healthcare places, people in state departments of health were begging the federal government to give them some discretion because they had a lot of Moderna or Pfizer generally on hand, but they didn't necessarily have the same amount of Johnson & Johnson on hand. There was a study submitted to the FDA regarding mixing and matching. In that study, it showed that Johnson & Johnson recipients that received a Moderna booster saw their antibody levels rise by 76-fold in 15 days, versus if they received the Johnson & Johnson booster, they saw only a 4-fold increase in those antibodies. So obviously a dramatic difference, but and consistent, the Pfizer results were also consistent as well with this jump, consistent with the Moderna booster jump. So what does it mean? If you are eligible to receive a booster shot, you can receive any shot that you want. So that is helpful to all healthcare facilities out there. And Kathy, can we have the next slide, please? Perfect. And the final approval, this is all, what we've discussed. But one thing to note is that and I thought that this fact was very interesting. In the US, 15+ million people have received Johnson & Johnson, 69.5 million people have received Moderna, and 104.5 million people have received the Pfizer shot. That was their first round, right? That was the first round of fully vaccinated, or one shot only, if you didn't complete the series. So obviously there's a lot more Pfizer, Moderna vaccines around, and that was really the reason why we needed to have this mixing and matching of boosters. All right, the question that I'm going to leave you all with, what about the HERO Act designation? Are we going to see it continued into November? This is where we've all been waiting for. So this is just a screenshot of the continuation from September into October. And in this, the Commissioner of Health says that one of the reasons why they extended this is because the CDC has identified the level of transmission of COVID-19 in New York State as substantial or high. Based on our trajectory of cases, yes, we are heading in the right direction, but New York right now is still at a high level of transmission. The only state here, state and territory, we have California and Puerto Rico, are the only ones that are at a moderate level of transmission. So if I had a crystal ball, I would bet that the HERO Act is going to be extended into November. But take a look at this, right? We've seen the cases drop dramatically over the past week. What will it take to get into that moderate transmission rate? It means that the total new cases per 100,000 people in the past 7 days has to be below 50. Right now, New York is at 138.6. If we continue on the trajectory that we are currently on, then we should be good to go. We should be good to go by December. If something happens in the meantime, that we may not be at the moderate level of transmission. And again, this is no foolproof way of knowing what the Commissioner of Health is going to do with the HERO Act. This is just, we are taking the only information that we have available to us and running with it. And so, my bet is a few things. One, do think that the HERO Act will be continued into next month. So plan on your plans still being activated. And two, if we continue to see a steep drop in cases in New York, there's a good chance that the HERO Act will not be extended into December. But that's only if we continue to see these cases go down. Holidays may prove to be a complicating factor in this analysis. And with that, Adam, I am kicking it back to you.
Katie, thank you as always. One last thing before I end the webinar. We still don't have the federal guidance, the emergency temporary standard, which will implement a vaccine mandate for employers with over 100 employees. We are obviously watching that. We know that last week, the regulation was sent to the White House for review. It is currently being reviewed. And we anticipate getting something from the White House within the next couple of weeks, but we don't know when the mandate is going to be implemented. I know there's been a number of objections to the mandate. The White House has been meeting with some business groups. So we will certainly keep an eye on that as well and keep you updated with any developments. So thank you again. Great to have you all with us. We look forward to seeing you again next Tuesday. Take care.